The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning and welcome to the Fourth Circuit. We're going to hear argument on our first case, Balmoral LLC et al. Versus Bayer Consumer Care et al. Before we get started, since we have so many lawyers and we have a cross-claim today, let me run through the order of presentation to make sure everybody's on the same page. So Ms. Eckhoff, on behalf of Bayer, will be first for 10 minutes, followed by Mr. Yellen for the government for 5 minutes on the trademark issue. And then Mr. McMull and Mr. Coleman have 7 minutes each on behalf of Balmoral. You can divide that how you want, but you're allocated 7 each. And then we go back to Ms. Eckhoff, who has 5 minutes of rebuttal. And then Mr. McMull and Mr. Coleman have 3 minutes each, which you can divide among yourselves as you want. And you'll be responding to Bayer's response to your cross appeal. So let's see if we can remember all that. This is the first case of a fairly long docket today, so the court may have questions. If we do, we'll give you a little extra time, but otherwise we'll be watching the clock. So with all that said, Ms. Eckhoff, if you want to begin.
Thank you, Your Honor. May it please the court. This is a case about Balmoral's ongoing efforts to deceive the American people about the source of the medicine they take. The decision for this court is whether to allow that misrepresentation to continue indefinitely or whether to give Bayer the chance to prove its claims at trial. Bayer and its predecessors have used the Flanex mark in Mexico since the 1970s in connection with the #1 brand of pain reliever there. Bayer's Flanex trademark is extremely well known, and the Trademark Trial and Appeal Board held that that mark's reputation does not stop at the Mexican border.
Just to help things along, the panel's going to be fairly familiar with the factual background. We've had parts of this case before, and since you have a number of issues, you may want to get directly to your legal arguments.
Yes, Your Honor. So as you mentioned, Bayer presented a number of arguments in its brief, but since time here today is short, I'd like to focus on 2. The first being that the district court erred by holding on summary judgment that Bayer's claims are barred by a statute of limitations, and the second, that Bayer's claims are not barred by latches. So I'll start with the statute of limitations argument. The Lanham Act, unlike the federal copyright and patent acts, for example, does not include a statute of limitations, and the district court erred by reading one in. The parties here agree that Ninth Circuit law governs the question of whether a statute of limitations should apply to Bayer's Lanham Act claims. And the Ninth Circuit's most recent decision on that—
the parties may agree with that, but we make our own decision on which law to apply, don't we?
Yes, Your Honor, but Bayer's argument, and we believe that Balmoral agrees, is that because Bayer initially filed its Lanham Act claims in California District Court, that Ninth Circuit and Central District of California law apply to that question under 1404.
Well, ma'am, if we agree that latches you're entitled to that, do we have to remand that back to the district court for fact finding?
With respect to the latches question specifically?
Right, yes.
Well, I think you likely would, Your Honor, because the district court, as of now, the district court disposed of all of Bayer's claims under a statute of limitations. So I think a remand likely would be necessary. The district court did not make a finding at all with respect to latches. It didn't reach that issue.
So with regard to the Lanham Act claims, if you're correct, we would remand for the district court to consider in the first instance
Right, yeah,
Correct.
on the question of latches.
Yes, Your Honor.
yeah, that's a great idea, yeah.
Well, Justice Ginsburg, not to belabor the point, would have disagreed with you on which circuit's law would apply, whether it's the transferee or the transferor's argument. It may not make a difference in this case, but we do have, I believe, one Fourth Circuit case, Bradley versus the U.S. from 1998, that holds that we cannot and do not apply the law of another circuit simply because the case was transferred from the other circuit.
Well,
So we may be bound by that. May not make a difference in the end, but
well, sorry, Your Honor, go ahead.
no, go ahead.
So our view on that point, that was the courts don't have a uniform view as to whether a statute of limitations should be applied to Lanham Act claims. There's some inconsistency across the country. That makes it a geographically non-uniform question. And because of that reason, that's why we believe that Ninth Circuit law should govern instead of Fourth Circuit law. We do, on the other hand, think that Fourth
Counsel,
Circuit law...
Judge Thacker has a question.
Oh, yes.
But what if we find that Fourth Circuit law applies? Where does that leave you?
So under Fourth Circuit case law, a majority of Fourth Circuit panels to look at the question have applied latches on the question of what sort of timeliness bar should be used for Lanham Act claims. So we still believe that latches would not bar any of Bayer's claims under the Fourth Circuit.
And what's your
All
best evidence that Bayer was not sleeping on its rights? It took years to file this claim.
Well, our best evidence there, Your Honor, is that Bayer acted quickly in filing the petition to cancel, which it did in 2007. The shortest potentially applicable state law limitations period is 3 years for the false advertising claims and 4 years for unfair competition claims. The earliest that Bayer possibly could have even had constructive notice of its claims was September of 2004. That's when its predecessor had their own Flanex application suspended by the Trademark Office due to Belmora's prior Flanex application. So that was September 2004. In fact, Bayer didn't even acquire rights in the Flanex mark from that predecessor until 2005. But even if we use the September 2004 date, Bayer filed its petition to cancel in June of 2007, so less than 3 years later. Combining that, the fact that Bayer decided to move with the Trademark Trial and Appeal Board instead of District Court makes sense because the Trademark Trial and Appeal Board has a lot of expertise in the issues of trademarks and trademark registration specifically. So Bayer wanted to take advantage of that expertise in getting a decision on the question. Additionally, all of the cases that have looked at this issue have found that board proceedings do toll limitations periods for subsequent related claims. And so Bayer relied on those decisions as well in making its choice to move with the board instead of going straight to federal court.
Ms. Eckhoff, let me ask you this question that as to your state law claims, how do they survive? Under a theory of equitable tolling or what?
Yes, Your Honor. Under California state equitable tolling, Bayer meets the 3 factors there. We believe that those claims are also barred or are also tolled by the filing of the cancellation petition because they're part of Bayer's federal complaint.
Same result if we applied the Fourth Circuit law?
Yes, Your Honor.
So as I understand it, the district court simply ruled that the statute of limitations under California law had expired, and it never dealt with equitable tolling or any other defense as to the statute of limitations.
That's
Is
right,
that
Your Honor.
right?
Yes, that is correct. The district court did not reach the latches issue. and did not reach tolling either. Doesn't discuss either tolling or latches at all in the decision.
Well, as far as the state claims are concerned, it would just be a question of tolling, wouldn't it?
Yes, yes.
And
that's
did, and
right.
did you raise that in the district court?
The tolling issue?
Yes.
Yes, yes. Our argument was that tolling applied to all of Bayer's claims.
So if we agree that that was an issue raised and the district court never addressed it, wouldn't we just remand it to the district court to address it again in the first instance?
Well, respectfully, Your Honor, we think that you could decide simply to reverse the district court's decision in finding that that Bayer's claims were barred by the statute of limitations, since that issue was raised with the district court. And here the review is de novo of the summary judgment decision.
Well, if it never made any, if the statute of limitations applies, but tolling may toll it, that would, I think, involve some factual determinations that have yet to be made. So we couldn't make those in the first instance, could we?
Yes, Your Honor, that's probably correct. It would make sense to remand.
All right, you've got 30 seconds left. What else have you got for us?
All right, let's see. So back to the statute of limitations issue briefly, Your Honor. Like I said, our view is that the Ninth Circuit law applies to that question. Pinkett is the most recent decision on point there. Pinkett applies latches instead of the statute of limitations, which we think is what the district court should have done in this case as well. And I see my time is now up.
Okay, and I take it the government is going to carry the ball on the trademark agency decision. You're not arguing that specifically.
We're prepared to discuss that, Your Honor, if you have any questions. But yes, because that's the bulk of the government's argument, we thought that we would leave it to them to focus on.
All right, thank you. You've got time left on rebuttal. Mr. Yellen, on behalf of the government.
Good morning, Your Honors, and may it please the court. Louis Yellen on behalf of the United States. Your Honors, we're here for two purposes. The first is to defend the district court's choice in employing a standard of review under which it reviews for substantial evidence, factual findings made by the board for which no new evidence was introduced in the district court action below. And second, to defend the board's decision to cancel the registration of Belmora's trademark because Belmora attempted to pass off its goods as those of Bayer's. On the first issue, the standard of review, the Federal Circuit for decades had employed a standard of review under which if no new evidence was introduced as to one particular factual issue, the district courts would defer to the factual findings of the board unless there was no substantial evidence to support those findings.
Well, let me ask you this question. Are we quibbling over the term new evidence or additional evidence? Because it seemed to me that there was additional evidence that was submitted to the district court. And wouldn't that be new evidence?
Judge Floyd, the question is new evidence as to what? Belmora's position, as we understand it, is if a party introduces new evidence as to any particular factual issue, that opens up the entire record for de novo review. That's not consistent with the Federal Circuit's precedent in this area. The question is, under the Federal Circuit, if there's a dispute as to one particular factual issue and new evidence is introduced that's related to that particular factual issue, then the district court engages in de novo review of that factual issue, but not the entire record. And if I might, Judge Floyd, I can give you an example that might make this a little bit more concrete. Imagine a trademark challenge.
Counsel, before you give your example, let me read you one section out of Capos. which says that we conclude that the proper means for the district court to accord respect to the decisions of the agency is through the court's broad discretion over the weight to be given to evidence newly adduced in the proceedings and the evidence that was taken below. So in the course of your example, see if you could address that language from the Capos decision, which seems to indicate that it's up to the district court when there is new evidence to accord weight to that evidence as well as what transpired in the agency.
I'll be happy to, Your Honor. So in the Federal Circuit's doctrine and in the government's view, there are two buckets. One bucket is factual issues for which no new evidence is introduced. And the second bucket is factual issues for which new evidence is introduced. Let's take as the example a challenge to genericness and a challenge to confusion. If a party introduces evidence as to confusion, but not to genericness, there's no call for a district court to engage in de novo review of the factual findings the board made as to genericness. But if new evidence is introduced as to confusion, then the board would undertake de novo review. Now, Judge Agee, the language that you just quoted refers to what the court should do when we're already in the second bucket. That is, when the court already must undertake de novo review because it has before it new evidence that the board had not considered. It was in that context, Your Honor, that the Supreme Court said, well, that doesn't mean that a court gives no consideration to the factual findings that the board made. When we're in that second bucket and a district court is engaging in de novo review, it nevertheless can decide what weight to give that new evidence. But nothing in the Capos decision suggested that the new evidence as to one issue would open up the entire record. And if I could point, Your Honors, to a particular quote, I think, Your Honors, if you look at every time the Supreme Court announces its holding, it's very careful to limit it to new evidence as to a particular factual issue. And this is one sentence, just one sentence that I'll read. At 566 U.S. 434, the Supreme Court said, "We hold that the district court must make a de novo finding when new evidence is presented on a disputed question of fact." The court didn't say when new evidence is introduced into the record. It specified that it's the disputed question of fact that triggers new de novo review. And that's consistent with the Federal Circuit's long-standing precedent. If the Supreme Court had intended to upend that precedent, we would have expected a much more specific explanation that the court intended for district courts to engage in de novo.
All right, Mr. Yellen, you're over time, but I do want to ask you one more question with that in mind, because here's what we said in Swatch following the Capos decision. Where new evidence is submitted, de novo review of the entire record is required because the district court cannot meaningfully defer to the factual findings if the agency considered a different set of facts. That's a little different than the Supreme Court's language in Capos. So if you can very quickly respond to that.
Yes, Your Honor. I'll try and do so in a couple of sentences. We agree that Swatch is at least ambiguous as to this point, but we think the best reading is to understand Swatch as not foreclosing substantial evidence review on questions of fact for which there is no new evidence. And what I would point Your Honors to is the second part of the sentence that you just read. That is, because the district court cannot meaningfully defer to the PTO's factual findings if the PTO considered a different set of facts. That refers to a particular factual dispute. If there's a factual dispute that the PTO had all of the evidence before it, there's no reason for a district court to open the entire record as to that particular factual dispute. And one last sentence on this, if I may, Your Honors. If you look at the particular issues that this court reviewed in the Swatch case, you'll see that what the district court did in that case that was erroneous was try to engage in substantial evidence review and de novo review as to the exact same issue, factual issues. So, for example, whether the mark was suggestive or descriptive, the district court said it.
Thank you, Mr. Yellen.
Thank you, Your Honor.
Unless the members of the panel have another question of you, we're going to move on to Mr. McMull. We'll be glad to hear from you.
Good morning, Your Honors, and may it please the court. I'm Joel McMull for Balmora LLC and Jamie Belcastro. I'm joined this morning by my co-counsel, Ron Coleman. Again, I'd like to reserve 3 of my 10 minutes for rebuttal. Your Honors, while substantial aspects of the district court's summary judgment opinion were unprecedented and wrong, the dismissal of Bayer's 5 unfair competition claims were not among them, as each were clearly barred by the applicable limitations period under California law. There are no material disputed facts regarding Bayer's improper delay, and the district court followed well-reasoned California law in finding that Bayer's filing of this action missed the limitations period by almost a decade. Bayer appears to argue that because the courts of the Ninth Circuit interpreting California law have found that the Lanham Act contains no statute of limitation, that's the end of the inquiry. But of course it is not, Your Honors, because in so stating, Bayer ignores that California courts borrow the limitations period of the most analogous state law, which under California law is either 3 or 4 years, depending upon whether a state claim for fraud or an analogous 4-year claim, unless an analogous unfair competition claim, which has a period of 4 years. The point here is
what happens if we disagree as to the Lanham Act claims that a statute of limitations applies and that laches would apply instead?
I would submit to you, Your Honor, that the result is exactly the same. Of course, the district court below never reached that issue, but for all of essentially the same reasons, for laches to, it is essentially the same. The period, I believe, under Virginia law.
Counsel, hold up a second. Judge Thacker has a question.
Thank you, Judge Agee. So if the district court never reached the issue of laches, I go back to Judge Agee's question earlier of opposing counsel. Don't we send it back for the district court to do that, assuming we disagree with you on the statute of limitations?
I don't think there's any need to, Your Honor. I think the record is sufficient to demonstrate that under Virginia law, which I believe has a 6-year period, even if Virginia law applies, I still think it's untimely. And there are facts. Indeed, Your Honor, I encourage the court to take a look at page 16 of our opening brief, at which point we set out no less than 6 events beginning in September of 2004 through August of 2009 in which Bayer and or its predecessor in interest were put on actual or constructive notice of Balmora's interest and use of the Flannex trademark.
But did the district court consider that in the context of laches?
It did not, Your Honor. It did not.
Okay, so why shouldn't we remand then for the district court to do that in the first instance? Again, assuming we disagree with you on statute of limitations.
Because I would submit to you that the record is sufficient as presented for Your Honors to make a determination that notwithstanding the fact that the district court didn't reach the issue, there is no material issue of fact to be determined.
And that's based on the listing you were just about to, that you referenced in your brief?
That's right, because whether it's analyzed under a laches or a statute of limitations defense, I would submit that the outcome is exactly the same.
Okay.
I don't know whether you're going to be arguing about your competition counterclaims, but what evidence in the record is that you can point to that Bayer knew or had reason to know that some third party was selling Mexican Flannex in the United States?
Well, Your Honor, again, my co-counsel, Mr. Coleman, will be arguing those issues, but I will just say one thing to that, which is that in its pleading in the district court action, it acknowledges that it was aware of illegal Mexican Flannex sales in the United States. Now, I believe there is some deposition testimony that goes to that issue as well. But again, I'm going to leave that for my colleague, Mr. Coleman, if I may.
That's fair enough.
And who's going to raise an argument about the trademark board decision?
I am, Your Honor.
That's
The
you?
14,
all right.
The 14.3 misrepresentation claims, Your Honor, we've had a nice scholarly debate this morning on the applicable standard to be applied. And while we submit that this court's interpretation and enunciation in Swatch is the correct one, which has also been corroborated by other courts, not the least of which is the District of Columbia, we believe that it really is an immaterial distinction. Because the board's findings were so tied and tethered to the notion of bad faith, the evidence that was submitted on remand goes to the very issue of Belmora's bad faith, namely the absence of bad faith, because Mr. Belcastro obtained approximately contemporaneous with seeking registration of his Flannex mark, the advice of counsel. And on remand, we submitted that in two instances, Your Honor. The first was in deposition testimony, which of course is included in the record, in which Bayer's counsel asked him what were the circumstances under which you obtained that. And the second is that there is a document. And while I acknowledge that it may just be a pottery shard, it at least contributes or corroborates rather Mr. Belmora's testimony that back in 2003, he obtained the advice of counsel, which indicated that in the absence of Bayer using the mark in the United States, and because at least before this court's prior ruling on appeal, we understood, or our client understood, trademark rights to be tied to territorial rights, he received the recommendation from his counsel that he could proceed with that registration.
All right.
So my point, in sum, Your Honors, my point is whether, regardless of whether we look at the entire record or we only look at what was ultimately produced as new evidence before the district court, it's an immaterial distinction, because when we recognize and we look at what that evidence is, it essentially undercuts the board's determination, or at least sufficiently so that it's a question of fact that should go to trial.
Well, if we did find the standard of review was relevant and the district court got a little off base on that, in the Swatch decision, we also found that the district court got off base, but it made sufficient findings that we could affirm the decision. And in this case, I'm looking at page 897 of the joint appendix. The district court appears to make several findings on that page with respect to its review of the new evidence. Would there be a barrier for us affirming the district court as we did in Swatch on that basis?
Well, yes, in a couple of different ways. For one thing, Your Honor, the opinion also states, and forgive me, I have not had the occasion to read that paragraph, but the district court's opinion also indicated that Mr. Belcastro's testimony was not credible. Well, of course, credibility determinations are not appropriately made on summary judgment. And so, notwithstanding the court's characterization of the evidence, I would submit that it really exceeded what it was able to determine on a summary judgment motion. So in that respect, Your Honors, yes, I would argue that there is a barrier for Your Honors to affirm the court's summary judgment decision in favor of Bayer on the misrepresentation claim that was decided by the board.
All right. Thank you, Mr. McMull.
Thank you.
Mr. Coleman? Hold up. We can't hear you, Mr. Coleman.
Unmuted.
If Mike Dean's listening, can he fix that?
No, we're good, Your Honor. Thank you. I had
All right.
muted myself to avoid any interruptions. If it pleases the court, thank you very much. I am here to discuss the counterclaims issue, the cross appeal, essentially. Our fundamental interest here is obviously with all the counterclaims, but the antitrust claim in particular, I would like to open my argument with. The court below did not reckon with the record. We have an unusual situation here. Usually there's a debate regarding market.
Hold up, Mr. Coleman. Your clock is not started. If the clerk will take a look at that and start the clock. All right, why don't you recommence and let's see if it works.
Okay. We have an unusual situation here with respect to the issue of market definition, which is often the threshold inquiry.
All right, hold up again. It's Mike, if you could take a look at that, it's not working.
Okay.
All right, let's give it a go.
We have an unusual situation here with respect to market definition. Usually the issue, a market definition is considered to be a threshold issue. And courts rely on expert opinion because it is sophisticated and analytical and typically a matter for experts. And here we do have an expert. We have an expert who said that when you look at the actual relationships that exist between products in a market, the ability of one actor, in this case Bayer, to affect affect competition and see what happened in the naproxen market, especially the naproxen gel caps market. You have defined a market for that product, and you have also defined market power. What you also have here, which is extremely unusual, is essentially a commercial admission by Bayer in the form of both testimony and documents, where it analyzes for its own commercial purposes the market for naproxen sodium entirely in the context of what are other market entrants, including Belmora, doing to Aleve. There's no consideration of what is Excedrin doing or what is Advil doing or what are other products doing.
Were you talking about Dr. Rosser as the expert?
Yes, Your Honor.
Okay, where in the record did Dr. Rosser speak to the relevant market here? I read his testimony as speaking more to the general market.
This is found, Your Honor, in the reply brief at page 23 on ECF numbering, or page 18 of the additional document number. So that's our excerpt from Dr. Rosser's testimony.
Okay, well that's what I was referring to. It seems to me to speak more generally.
Well, he does speak generally and in his testimony, but in his report he details, and that can be found, Your Honor, in the Joint Appendix, Volume 3, his report begins at a JA 1103, but I would direct Your Honor's attention to JA 1108, where he discusses precisely what happened in the gel caps market and also how a single product, and in this case naproxen, can be separated and identified as a sub-market by virtue of its properties as a pharmaceutical, by virtue of how it's marketed, by virtue of who buys it. For all those reasons, at the very least, we're talking about a summary judgment here, Your Honor, to say that that at the very least a question of material fact was not raised, or to say that as a matter of law, no jury can find that a relevant market or sub-market was identified here, we believe was error. Now, if I may, because the court did ask the question about the issue of the secondary trademark liability. The record, as Mr. McMull pointed out, does indicate that they are, in its own pleadings, adverted to the fact that that it was that its own sales of not actually of its own sales, but those of a non-party here, which is its Mexican affiliate, were being affected by the defendant's conduct. We would also point out that willful blindness does not require actual knowledge of the sales, but rather of a condition that which should cause reasonable inquiry. And we put before the court in the briefing and in the appendix testimony and documentation concerning a news report of Mexican Flanax that had been found by a reporter in the United States, and what our testimony and what deposition testimony indicated was that Bayer didn't follow up on it. Bayer did not do an investigation about it. Bayer had no, and as far as the record goes, still has no procedure or process for monitoring whether Mexican Flanax is sold in the United States, considering that it's against the law for it to do so. That would constitute at least a reasonable question going to willful blindness under the secondary trademark.
Well, I mean, other than this example from that one TV report, and I thought they had contacted the reporter and asked them to send them the box and that sort of stuff. How does that create a cause of action for your client?
Because my client has the trademark for Flanax, and if our if Bayer is selling Mexican Flanax in the United States, then Flanax, then Balmora, which is
but what's your evidence of that though? I don't recall any evidence in the record that tied Bayer to sales in the United States.
If sales are taking place in Your Honor, you just recited that evidence. The fact that Bayer was not aware that its product was being sold, certainly the court would not suggest that if shiploads, truckloads of Mexican Bayer showed up, Mexican Flanax showed up and were being unloaded in El Paso, and Bayer said, "Well, listen, we're not selling it. It's not our problem."
Well, do you have any evidence of that?
Well, Your Honor, the only difference between the evidence you recited and the hypothetical that I just gave is the volume. We have evidence that Bayer is aware, and in fact that it pleaded that its affiliate is aware of sales of its product in the United States. That's a trademark infringement. If Bayer is a proper party here to make a claim, it's certainly very much a proper party here to be responsible for the sales, which it claims were cut into by the conduct of our client.
All right. What else you got, Mr. Coleman?
Well, Your Honor, given that I'm out of time, those were the main points we wanted to hit. We think it's important that the court recall here again that the trial court's role here was not to weigh evidence. We believe that sufficient questions, especially on the antitrust question, were raised to go to trial on the antitrust issue, and as well as the tortious interference claim.
All right. Thank you very much. Ms. Eckhoff, you've got some rebuttal time.
Thank you, Your Honor. First, I'd like to briefly address the alleged new evidence that Mr. McMull mentioned, what he referred to as a pottery shard. So this is what they claim to be a 2003 trademark clearance opinion letter. However, there's no credibility assessment that the district court made about that letter. It simply found that there isn't any reason to believe that the letter exists. It's not in evidence here. It's never been produced. The law firm that allegedly wrote it, Jacobson Holman, they were never subpoenaed for a copy of the letter. And more specifically, in 2009, Mr. Belcastro, Balmora's founder, was deposed and was specifically asked whether any attorneys were involved in his adoption of the Flanax trademark in the United States. And he answered unambiguously, "No, sir." So the claim now that there was an opinion written in 2003 directly contradicts that prior deposition testimony. Let's see. With respect to the antitrust claim and Dr. Rausser, I would direct the court to page 48 of Bayer's response brief, where we address Dr. Rausser's testimony. Here in the Fourth Circuit does require expert testimony to define the relevant market for an antitrust claim. And here, Dr. Rausser was asked, quote, "In your August report, do you identify the relevant market that Bayer has allegedly monopolized or threatened to monopolize?" Answer, no. Question, did you regard that as part of your assignment? Answer, no. So unambiguously here, we do not have any expert testimony defining the relevant market. That is a decisive issue on the antitrust claim. With respect to the alleged commercial admission by Bayer about what the market is for its Aleve product and whether or not there is a defined market or sub-market for branded naproxen sodium liquid gels, as Belmora claims, this alleged commercial admission is an internal marketing PowerPoint that was created by a Bayer salesperson dealing with a small amount of sales that Bayer's Aleve was losing at Walmart because of the introduction of Belmora's Flanex there. There's plenty of case law in the Fourth Circuit that says that internal marketing documents do not constitute the type of evidence that's necessary to define a market for antitrust purposes, because that definition is very complex. It's something that is reserved for experts, which is why the Fourth Circuit requires expert testimony. And the way that business people, marketing people use the word market is different than the way an expert economist uses the word market when they're talking about antitrust. So that PowerPoint is certainly not an admission by Bayer about what the market might be. With respect to the 2008 news report, Judge Floyd, you are correct. There is evidence in the record that Bayer's global HR director, who was informed about this news report, immediately responded to the reporter and asked the reporter where they found this Flanex, and also asked that the box be sent to Bayer so that they could look into the matter. This was back in 2008. There's no evidence that Bayer didn't take any further action with respect to that. Additionally, with respect to your question about whether there are truckloads of Mexican Flanex being brought in, across the border, the answer is no. And more importantly, there is no evidence whatsoever that Bayer had anything to do with Mexican Flanex crossing the border. In fact, Belmora itself used to make that argument. When this case was back before the Trademark Trial and Appeal Board, Belmora argued that just because there were, a few isolated instances of Mexican Flanex found here in the United States, that was not evidence that Bayer had anything to do with it. There is no evidence in the record that Bayer has sold Mexican Flanex here, nor would it, because the dosage in Mexico is higher than the dosage that's permitted here by the FDA, so Bayer's not going to sell it. There's also no evidence that Bayer knew about any particular importers or sellers of Flanex here and either induced those parties into acting or supplied them with Mexican Flanex. There's no evidence of either of those things. And let's see, I think that's the end of my time.
All right, thank you, Ms. Eckhoff. Mr. McMull, you've got 3 minutes to.
Thank you, Your Honor. Thank you, Your Honor. I do want to raise the issue of latches if I can. I know that we previously spent some time on that. Latches is a valid defense where a plaintiff's delay in bringing suit is both unreasonable and would cause prejudice to the defendant. I would submit to you that the record is extremely fulsome on both of these issues. Reasonableness is determined by looking at the state's limitation period. And Ninth Circuit law makes very clear that if the filing of a claim is filed after the limitations period, then there is a strong presumption that latches applies. With respect to prejudice, there are two kinds of prejudice. The first is expectation prejudice, which in this case, Mr. Belcastro and Belmora LLC for 10 years were certainly, enjoying revenues and putting money into their company in the millions of dollars. they came to rely on, and I think rightfully so, the acquiescence of Bayer in claiming that it had a problem with respect to a purported infringement claim or injunctive relief. The other prejudice that I think is very clear from the record that Balmora has sustained is that which relates to evidentiary prejudice. In this case, we're talking about, memories have faded, Your Honors. We're talking about events that happened 15 years ago. Certain witnesses are no longer available. Certain documents are no longer available, not the least of which, of course, is this 2003 opinion letter that regrettably has not been able to be discovered, in part because Mr. Balmora's former trademark counsel, among other things, had a security breach of their law firm and their data that precluded the production of the document. And while I appreciate that's not in the record, there is certainly prejudice here from a documentary and testimony perspective that Balmora has suffered. The additional prejudice from an evidentiary perspective is that because certain email communications, and there was a migration of email systems, that has resulted in the loss of documentation. So my point, Your Honor, here is that there has been some serious prejudice that Balmora has suffered arising from the protracted delay that Bayer engaged in before filing suit in 2014.
Okay. Thank you, Mr. McMull. Mr. Coleman? Mr. Coleman, I think you're muted again.
I'm just too good for my own sake here. Too well behaved. So, Your Honor, I would like to just go back to this issue of expert testimony. Going again back to the reply brief where Dr. Rausser says, it's not at the bottom of page 18. It's not the scope of the it's not that the scope of the relevant market is not important or can be swept under the rug. Instead, it's a question of whether there is a market linkage that allows the market position of one supplier to the market to actually abuse their position. And if they can, there's got to be some market where they exercise that power. And as in my exhibit 1, the market where they can exercise that power is upstream with regard to the manufacturing of the Aleve product, the liquid gel product in particular. The district court didn't wrestle with that testimony at all. And that was the error here. Merely relying on the quotation by Bayer of a gotcha question at a deposition is not good enough. Dr. Rausser's testimony, it makes it clear that Bayer had, and the facts make it clear, that Bayer had a complete veto over the market for inputs, the sale of raw naproxen liquid gels to any branded competitor. If that's not the definition of anti-competitive behavior, it's hard to imagine what is. You have a competitor who wants to go and who wants to offer a product to compete with yours. You pick up the phone, or the phone rings and someone says, listen, I want to sell the raw material to your competitor. Is that okay? And the competitor says, well, who's the competitor? Oh, Balmora? No, it's not okay. Shut him down. How is that not an attempt to monopolize if it's not monopoly? It's impossible to conceive of a more straightforward, transparent example of anti-competitive behavior.
All right. Unless the panel has any further questions of counsel, we thank you all for your arguments today. If you've argued in the Fourth Circuit before, you know we would come down and shake hands, but we can't do that now, so consider this your virtual handshake, and we look forward to seeing you when we can be together in person. So with that, the court will take a short recess pending the setup for our next case. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honors.
This honorable court will take a brief recess. of the United States Court of Appeals for the Fourth Circuit.
All right, we're ready for argument in our next case, Lenz versus the United States. Ms. Malarkey.
That is me, Your Honor. May it please the court. This case raises two issues. I'd like to start with the issue involving the discretionary function exception to the Federal Tort Claims Act, which, as Your Honors is aware, is a remedial statute, and all exceptions to it are to be read narrowly. The purpose of the act is to allow private citizens to sue the federal government and hold the government liable when their employee is acting in the same manner and to the same extent as a private individual would be liable. The discretionary function exception to the Federal Tort Claims Act is interpreted using a two-part test that is laid out by the Supreme Court. The first part of that test states that if a regulation or governmental policy requires a course of action, the government cannot be held liable so long as that prescribed course of action is followed. In this case, we have a prescribed course of action that was not followed. And as a result, the discretionary function exception should not have applied. In our case, we have a situation where the Veterans Administration, that was the entity, the federal entity that had a residential drug and alcohol treatment program for veterans in which Mr. Lenz was a patient, had a patient safety policy. It is found on starting on page 58 of the joint appendix. And that policy prescribed a course of action. It required zero tolerance for patient abuse. Patient abuse was defined within the policy. Patient abuse included the development of a personal relationship of a non-therapeutic purpose between a therapist and a veteran that was enrolled in the program. And it required that when there was such abuse, this is on page 59 of the joint appendix, at a minimum, the supervisor will assign the alleged abuser, upon receiving notice, to duties that do not involve...
Excuse me, Ms.
Judge
Malarkey.
Thacker has a question.
Yes, Judge.
Thank you, Judge.
Yes.
Yeah, I can see how that policy may go to the negligent supervision claim, but is it applicable to the negligent hiring and retention claim? And if so, how? And if not, is there another policy you would point to with regard to those claims?
So, Your Honor, I think it's fair to say that although the complaint, I do believe from memory, it captions count one, negligent hiring, supervision, and retention. Really, the gist of the allegations that we were making in the complaint relates to the supervision and retention, not the hiring. There was no allegation in the complaint that the Veterans Administration knew before it hired Ms. Burns, Dr. Burns, that she had a propensity to engage in private personal relationships. But the thrust of our complaint and what is alleged in the complaint is that the government learned during the course of Dr. Burns' treatment of Mr. Lenz that in fact she had developed such a personal relationship and thereafter failed to properly supervise her and retained her when it should not have. So I hope that answers.
I thought that when the government found out about Mr. Lenz and the doctor going to a wedding, they told her that was inappropriate, and they took her office away and did other things to, I guess you could say, supervise her that were in accord with their policy.
Part of what Your Honor has summarized is correct and part is not. So what the complaint alleges is that they learned, her supervisors, that she planned to attend a wedding with him off-site for personal reasons, told her that was inappropriate, but then thereafter allowed her to continue to care for Mr. Lenz for an extended period of time. It was not until another male patient, not Mr. Lenz, someone else, raised a complaint against Dr. Burns that she ultimately was removed from patient care and assigned to administrative duties. So our complaint, go ahead.
How do you deal with this court's decision in Souter that seems to hold that government employers' hiring and supervisory decisions are discretionary functions as a per se rule?
So the court did make that comment in a footnote in Souter. That comment in a footnote in Souter has been repeated in other decisions in the body of the opinion. And I would say two things about that. Number one, to the extent that this court has made a blanket proclamation that all negligent hiring, supervision, and retention claims are barred by the discretionary function exception, I think, with due respect to the court, that decision is simply wrong. I don't believe in Souter or any of the subsequent decisions the court has really given the thought and analysis to that holding to the extent that it is a holding. Setting aside negligent hiring without really getting into it, because as I've said, that's not really a part of our case. Our position is, Mr. Linz's position is that when the government has specific knowledge of an unsafe condition or of misconduct by one of its employees, the discretionary function exception is not implicated because there can be no sound public policy of a social, economic, or political nature supporting the decision to not do something about that. And so
let's if we assume that just for argument that your position has some viability, other than knowing that Mr. Linz and I can't remember the doctor's name, but the doctor was they were going to a wedding, what other evidence was there alleged that the VA knew while the doctor was treating Mr. Linz?
In the complaint, and at the time the complaint was filed, that was all that was known. It was brought to their attention that she planned to attend a wedding and that there was a meeting wherein she was told that's not appropriate, you can't do that, but was allowed to continue to treat Mr. Linz. We did raise.
So that's your basis for liability, is that one event?
Having not had the benefit of discovery, Your Honor, that's correct. We did argue, and I do believe we were entitled on the scope of employment question to have discovery, which is a separate issue that's raised in the briefs and the papers below. But without the benefit of being able to depose the supervisors to know what exactly they knew and when they knew it, that was the evidence that we had at the time. And I do believe that it is sufficient. When an employer is notified that a therapist intends to go to a wedding, which is clearly a personal, not happening on VA property, not happening as part of the therapy, not happening as part of the program. Yes.
And so would that alone be a violation of the zero tolerance policy in your view?
I do believe that it is. The policy specifically defines patient abuse as a non-professional relationship. I'm going back again. I keep looking to the side because the policy is on this monitor to pages 58 and 59, but a non-professional relationship. And the policy states that the professional shall be removed at least from treating that particular individual until the complaint is investigated. And that, as alleged in the complaint, didn't happen here. Getting back to the discussion about Souter and negligent supervision and retention, there are a number of cases that, in my opinion, unlike the Souter and the several other cases of this court, that do really analyze and provide thought to the question of whether when an employer, a federal employer, specifically receives notice of an employee negligence or indiscretion or any practice that is unsafe and fails to act, that can in fact be the basis for a negligent supervision or retention claim against the federal government, and that the discretionary function exception is not implicated. And
even under your theory, you seem to have this one event where they were going to go to a wedding, carry an awful heavy load.
I understand, Your Honor, but without the benefit of discovery at the time the complaint was filed, having the benefit of only being able to speak to Mr. Linz, that was the information that I had, and that is what formed my good faith basis for the complaint. And I do believe that had we had the chance for further discovery, we may have been able to ascertain more. But like some of these other cases that are cited in my brief, including Tonelli, which is a decision of the Ninth Circuit, and there's a couple of other district court decisions, it is not a per se rule that negligent hiring and supervision and retention claims are always barred by the discretionary function exception. And just so that I can reserve a few minutes for the next issue, I will just refer the court back to those cases and state that when there is specific information of negligent or intentional misconduct by a federal employee that the employer is aware of, that does not implicate any reasonable social, economic, or policy, and the discretionary function exception as such should not apply. And I think, interestingly, the district court actually on page, this is on joint appendix page 150, in the section where the district court was discussing the scope of employment question, made a comment that in most instances, an employer is not protected by sovereign immunity from a negligent hiring, supervision, or retention claim, which entirely contradicts the holding of the first issue. But turning to the scope of employment issue very briefly with my remaining time, again, I do believe that this question should have been subject to discovery under this court's decision in the Kearns case.
But Ms. Malarkey, even under what could discovery possibly unearth that would make the conduct here, which is clearly unethical and malpractice, fall within the scope of employment? Doesn't Maryland law say that the action has to be authorized by the employer?
Yes, it does.
The zero tolerance policy hurts you here, doesn't it?
I'm not sure that it does, and the reason being that the Maryland law, yes, you're right, does say that in order to be found within the scope of employment, the conduct has to be incidents to the performance of one's work duties. But the court has also said, this is the Maryland Court of Appeals, that even if conduct is in direct opposition to the master's express and positive orders, it can still be held to be within the scope of employment if it's incident to the work duties. And here, I think, to answer your question about Maryland law, there is no Maryland reported decision that I am aware of or have ever been able to find in 15 years of practicing medical malpractice that analyzes the question of whether a therapist, a mental health care provider, can be acting in the scope of his or her employment when they use the therapeutic relationship to manipulate a patient into having a personal, private, and sexual relationship. And I think the answer to that question is yes, in the context of a mental health care provider, because mental health care providers are uniquely situated. And this is to answer your question, where discovery, I think, would have been able to elaborate on this question, because we could have taken depositions of Ms. Burns's, Dr. Burns's supervisors to learn more about this program, how the program was run, what her job expectations were, and have the benefit of expert testimony to explain that the therapeutic relationship is a unique relationship. And in this particular case, the allegations were that Dr. Burns manipulated that relationship of proper therapy by saying things like Mr. Linz needed to have intercourse with her in order to to get over his intimacy problems, to have eye contact with her to get over his intimacy problems, to get over his feelings of being gay from incidents that had happened to him when he was a child. That is taking the therapeutic relationship and manipulating it in a way that is, in fact, incident to the performance of one's work duties. And
but under the scope of employment, I mean, the actions have to be foreseeable to the employer, and it cannot be a personal action by the abuser, so to speak. And I think that you all pled or argued something to the effect of saying that these actions had no therapeutic purpose, which would seem to make it along the personal lines. And if I'm remembering correctly, the doctor went to great lengths to keep secret the relationship. So it seems like you've got some difficulties both on the foreseeability and the personal aspects of the scope of employment.
I think that is where discovery would have provided more information to the court to make this determination, Your Honor. Recognizing my time is about up, I will just say that expert testimony absolutely would have explained why there is a transference phenomenon that goes on between patients and therapists, and it works both ways. a patient can develop feelings for a therapist can develop feelings for a patient, and that is incident to the therapeutic relationship. And I do believe that with the benefit of discovery and expert testimony to explain those phenomenon, and this is what has been found in the other cases that are cited in my brief, that is in fact in this unique relationship part of or incident to the scope.
All right, thank you, Ms. Malarkey. Ms. Nichols?
I think you're muted.
I am. Apologies. May it please the court, Roanne Nichols for the United States. Your Honors, I would like to start where perhaps Ms. Appellant's counsel left off, and that's discretionary function. The sovereign immunity is to be narrowly construed, and the exceptions mean what they say. Appellant's counsel, the concern expressed about the lack of discovery is somewhat limited here, because appellant's counsel sued Dr. Burns individually in her individual capacity in state court. And while the motions were pending in this case, took her deposition in that proceeding in state court. So she did have information, has information. There's about what Dr. Burns would say about what her employers knew about the relationship. And as the court pointed out correctly, what the government learned, what the VA learned in this case was that another patient, another veteran, filed a complaint against Dr. Burns. It was not sexual in nature, but it was a complaint. And 3 days after that, the VA terminated her clinical privileges. Yes.
Okay.
Yes, Your Honor.
But Ms. Nichols, the VA did also know about this wedding that they were supposed to attend, which clearly violated the zero tolerance policy. And what did the VA do then?
Your Honor, this is not the government's information, nor do we believe that it was information that Dr. Burns disclosed to counsel.
Wait, what you're saying? You're saying that the VA did not know about the wedding they were supposed to attend?
That's correct, Your Honor. If you look at the complaint, this is Joint Appendix 11, the statement is upon information and belief the supervisors knew and had a meeting. That did not occur with respect to the wedding. It was not known to the VA. And in fact, if it had been known, Mr. Lenz had the opportunity, actually.
Well, but I guess we're taking the allegations of the complaint at this point. We don't have discovery. So if the VA did know about the wedding that they were to attend, what was the VA to do under the zero tolerance policy?
Well, actually,
were they supposed to separate them from, remove her from the doctor-client, doctor-patient relationship at that point?
If they knew, that would be correct. Your Honor, the allegations contained in the complaint are stated.
Somewhere, either in the complaint or in the briefing, there's the representation that the VA told Dr. Burns not to go to the wedding.
Your Honor, that is a statement made on upon information and belief before counsel took the deposition of Dr. Burns. And had Dr. Burns supported that information,
right. But at this point, though, aren't we in the position where we take whatever's in the complaint as alleged to be truthful?
So
we have to, we have to accept the fact that they knew about, the VA knew about it, and they told Dr. Burns can't do this. So I think Judge Thacker's question was there something else that the VA was supposed to have done at that point?
The policy the zero tolerance policy does not demand a separation of the therapist and the patient. That would have been perhaps the step that could be taken. But
where am I supposed to look where it says it does not demand the separation of the therapist and the patient?
Your Honor, that would be in the the VA policy. That's Joint Appendix 59.
So is the VA making a discretionary judgment at that point? What's the import of that?
Your Honor, there would be some room for some element of discretion that the VA could exercise. But so for example, review all pertinent information to determine whether the allegation is sufficiently credible to require a board investigation.
Tell us where you're reading that.
Joint Appendix 59.
I'm reading Joint Appendix 59 that says, at a minimum, the supervisor will assign the alleged abuser to duties that do not involve the delivery of patient care to the alleged victim, and the supervisor will instruct the alleged abuser to avoid all contact with the alleged victim. At a minimum.
Yes, Your Honor. Oh, that's correct.
Okay, that's what I said before, and you said that they didn't have to do that.
The other question becomes, what is the investigation that is undertaken by the VA to determine the credibility of the allegations?
Right.
And that is under F.
Yeah, that's after the at a minimum, remove the separate the two.
Yes, Judge.
Okay. Go ahead.
The other issue is the extent to which the invitation to a wedding, assuming that it is true, is sufficient to first bring the conduct within the scope of employment, and also to deprive the VA of any discretion to take action on that count. And the district court found that the allegation was not sufficient for either purpose, in particular scope of employment.
Okay.
Well, ma'am, is it true that the VA did not do that separation despite the knowledge they had until later complaints were filed? Is that true about the timing of the incidents?
That's correct, Your Honor. Assuming the truth of the allegation, as the court must for purposes of a motion to dismiss for lack of subject matter jurisdiction, assuming the truth of that allegation, assuming that the VA knew, the VA undertook to terminate her clinical privileges after another veteran filed a complaint, and the VA at that point immediately suspended her clinical privileges.
Well, based on the allegations in the complaint, what the VA knew was that Dr. Burns was going to go to a wedding with Mr. Lenz. So I guess the question is, what makes that one event an action that would require some duty under patient abuse? So what do you say to that? Why is that evidence or not evidence of patient abuse? If that's all you've got to go on, what is it?
The fact that a patient may have invited his therapist to a wedding does not implicate patient abuse on the part, or may not implicate patient abuse on the part of the therapist, which is what may have been the case here. It doesn't necessarily, if that's the act, if that's the only act that implicates the policy or that implicates the relationship, that's we would maintain that that's insufficient. It's not enough.
So what's the basis to say that it is enough or it isn't enough? That's what I'm trying to get at here. If that's, and apparently based on the complaint, that's the only thing known to the VA was this wedding invitation. The opposing counsel says, well, that's enough. That's patient. That's in effect patient abuse, and so Dr. Burns should have been segregated from her client at that point. And you say no. What basis do you have to say that? I mean, that seems to be that would seem to be a discretionary judgment call on the part of the agency at that point. But I mean, what's your argument there?
Your Honor, the argument relates to the facts of this case. The invitation to the wedding, if the government had knowledge of it, occurred in November or October of 2015. In December of 2015, Mr. Linz was discharged from the VA, but the relationship between Dr. Burns and Mr. Linz continued. It continued through June of 2016. After the other veteran made the complaint about Dr. Burns, after her clinical privileges were terminated, after Dr. Burns resigned from the VA, after she resigned from the VA, that relationship continued, which, you know, indicates that had the VA removed Dr. Burns from his therapeutic duties, the relationship would have continued. The relationship had nothing to do with the scope of employment, did not advance the business purposes of the VA, was not authorized by the VA, and it continued nonetheless months after this purported invitation to the wedding.
Okay.
Yes.
Can I
Yes.
go back to the discretionary function exception? Can you? I'm having trouble seeing how Fourth Circuit law has categorically barred negligent hiring under the discretionary function exception in Souter when that is just in a footnote and also doesn't provide any analysis at all. So how is, or do you think that the Fourth Circuit has categorically barred negligent hiring under the discretionary function exception?
The question really is tied into government knowledge, at least the discretionary hiring decision, because that turns on, well, what did the government know about the employee, the potential employee, when the employee was hired?
Okay, so do you think that the Fourth Circuit has categorically barred negligent hiring under the discretionary function exception?
In the district court talked about an amalgamation, and this was Andrews versus United States, where the court.
So that sounds like a no. It hasn't. An amalgamation sounds like it's not categorically barred.
It's not categorically barred it may be
Okay.
categorically barred standing on its own, Judge, but it may not be barred if there is a knowledge component that is attendant to the hiring decision, and particularly the facts indicating that the employee should not have been hired.
Well, I think,
Okay, go
I think
ahead.
this case, I didn't understand opposing counsel to emphasize the hiring part. It was more of the supervision and retention part.
Yes, Your Honor.
So maybe I'm fixated on the wrong thing here, but it seems like that the whole crux of the plaintiff's case is that the invitation to the wedding, once known to the VA, was patient abuse under the zero tolerance policy, and that's what gets her to having stated a claim that would get past a motion to dismiss. So tell us why or why not, and if you can point to in the policy, why that would not be abuse. Of course, that begs the question of why it was abuse, but it seems like to me if that was not abuse that came under the policy, then plaintiff doesn't have a case.
Your Honor, another perspective to look at this, if I may suggest, is to start with scope of employment. Because was the conduct, the sexual misconduct by Dr. Burns, was that within the scope of her employment? The answer to that is no. And if the government, the VA, had no reason to know, no basis to know about this sexual misconduct, that's one element of behavior. On the other side of it, you've got an invitation to a wedding, and assume the government knew about that. Well, the sexual misconduct can put that in. Yes, Judge.
I might be confused, and I know I think I misspoke earlier when I probably said negligent hiring, and I meant negligent supervision. But I think what at least I'm looking for, and maybe Judge Agee is as well, is assuming the allegation in the complaint about the wedding, attending a personal event outside of work, is true, as we have all we have right now is the complaint. Does the zero tolerance policy bar that? And if so, where? I mean, is it okay for a therapist to go on a personal jaunt to a wedding outside the therapeutic relationship with a patient under this policy?
Not under this policy, Your Honor, and not under policies of the American Psychological Association, Maryland statute. No, it's not appropriate.
Okay, and then getting back to my question earlier, do you think that the Fourth Circuit, I think I said earlier, categorically bars negligent hiring, but I'll switch it to what I really meant. Does the Fourth Circuit categorically bar negligent supervision claims under the discretionary function?
Well, Your Honor, I think it depends on how we as litigants look at pronouncements from the court. And the court may say, may state that the government's negligent supervision, negligent retention is a discretionary function. But there are always cases and there are always facts where the court may re-examine that holding in another case and say, but in this case, with the information before the court, in this case, when we know that the conduct that's alleged relates to attending a wedding, we have no other background conduct, that perhaps there's another way to approach it. And the court may say the discretionary function is not absolute if the government knows, as alleged, that there's a plan to attend a wedding. I think that knowledge, and I believe that's what the district court was referencing in the opinion about the amalgamation of discretionary function and government knowledge and the effect of government knowledge on DF. Did that answer your question, Your Honor?
I think so.
I wouldn't say that there's a categorical rejection of any doctrine by a court, because the court can always revisit that, and courts do revisit it given the facts of a case, a particular case, and what's involved.
Understood.
But I would
All
ask
right.
the court to focus on the issue of scope of employment. Thank you, Your Honor.
All right. Thank you, Ms. Nichols. Ms. Malarkey, you have some time in rebuttal.
Yes, just piggybacking off of what Ms. Nichols just said, there are two distinct theories of liability here against the government. They are not to be confused with one another.
Right. I was gonna ask you that if you lose on the vicarious liability issue, is it over? Do you have a separate claim that we need to consider? That is the negligent supervision.
Correct, Your Honor. The latter of what you said. There are two distinct theories of liability. One is that the government is vicariously liable for the actions, the malpractice, abuse of the therapeutic relationship of Dr. Burns. Respondeat superior, that is where the scope of employment analysis comes in. Separate to that is the theory of liability for negligent retention or supervision after having knowledge of this potentially inappropriate relationship and failing to act. So I do think it's possible that I could lose on one of those issues and yet be permitted to proceed on the other. With respect to the discretionary function exception, that also is a two-part analysis. So I think we've talked a lot about the zero tolerance policy. I don't have much else to say about that, but I will just add that even if that policy does not prescribe a specific course of action that was not followed here, there's still another way for Mr. Lins to get around the discretionary function exception. And that's because the Supreme Court has said that even if there is an element of choice, the choice must be of the nature the exception was designed to protect, specifically decisions based on public policy. And I think Judge Agee made a comment that it would be discretionary of the government to determine what to do. And I respectfully disagree. I don't think that those kinds of decisions, when the government has knowledge of an inappropriate action or a dangerous condition, that there is discretion that is shielded by a public or social or economic policy. I think if that were the law, then the exception would follow the rule. And I think, I've cited in my brief the Indian towing case, which is a case involving a lighthouse, that was negligently maintained. And the government said, once you embark upon, maybe the decision to build the lighthouse is one that is founded with public policy, but once the government undertakes to do something, it has an obligation to do that in a non-negligent fashion. And so if you're not maintaining the lighthouse, then you are liable under the discretion, and the discretionary function exception does not apply. And that is the principle that I'm advocating here. It's that setting aside. So do you
see this as a case of per se liability?
No, I think that this is a case involving, it's per se if the zero tolerance policy applies. And I think that answers the question. But like I said, even if the zero tolerance policy doesn't apply, I still think that there should have been discovery. It should be up to a fact finder. The government hasn't even in this case articulated what is the social, political, or economic policy that allegedly was implicated by the decision to retain and not supervise Dr. Burns. We don't even have an argument as to what that was. And I think the reason is that there isn't one. Those are ordinary questions of negligence. And the cases
so if a plaintiff files a complaint that would relate to this policy and sets forth an act that they allege to be contrary to the policy, is that sufficient in and of itself to get past the motion to dismiss?
if there is a policy out there and the government actor has failed to follow it, then yes, the discretionary function exception does not apply. I'm talking about a situation where there is no stated policy, because then we undertake a different analysis under the situation. And so like the cases that have been cited in my brief with the lighthouse, there's a case involving harmful conditions in a commissary on a military base where there was mold in the meat department and the government had knowledge of it. There's even cases in the context of very factually similar to this case with the Bureau of Prisons and guards, that the Bureau of Prisons specifically had knowledge that those guards had a propensity to attack in a sexual nature prisoners. And the courts have said that when that government has knowledge of an unsafe or dangerous condition and they do nothing, there is no social or economic policy that is implicated, and therefore the discretionary function exception does not apply. I hope that answers your question. I just would like to factually make one statement before closing, and that is Ms. Nichols stated that the only thing known to the VA was that Dr. Linz was invited to a wedding by the patient, Mr. Linz. I'm sorry, I think I just said Dr. Linz. Dr. Burns was invited. That is not the information that I had. That is not the information that was pled in the complaint.
And it's not what's alleged in the complaint.
Correct. It's not what's alleged in the complaint. And again, because we didn't go forward with discovery, I was not able to depose the supervisors to find out specifically what information they had and when they had it. And the fact that the relationship continued after Dr. Burns was removed for patient care, the government had knowledge of that wedding long before, and it was the allowance of this relationship to continue for an extended period of time that led it to develop into what it was, all during a time that Dr. Burns was employed by the VA and treating Mr. Linz on a daily basis. And so either under analysis of the discretionary function exception, I think that Mr. Burns has stated the case. My time is up unless there are any other questions.
Seeing none, I'll thank counsel for their arguments in this case, and the court will take a short recess before our next case.
Thank you. Thank you.
This honorable court will take a brief recess. So Saturday. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
We're ready to hear argument on our next case, Skibo versus Greer Laboratories. Mr. Bograd.
Yes, thank you, Your Honor. May it please the court, Louis Bograd for appellants, relators Skibo and Pat. This is a False Claims Act case for defrauding federal health care programs into paying for the cost of unlawful mixes of allergenic extracts. The only issue before the court on the principal FCA claim is the question of scienter. The district court erred in finding no genuine dispute as to scienter. Relators offered more than sufficient evidence for a jury to find that Greer knew or recklessly disregarded the fact that its custom mixes violated FDA regulations. That's biologics.
What is your best evidence of that?
Your Honor, I have considerable evidence of that. I'm about to proceed through 4 separate categories of evidence on that score. I'll leave it to you to tell me which is the best, but I think it's all fairly substantial. The 4 categories of evidence the plaintiffs offered below are the following. Greer's explicit efforts to mislead the FDA about the nature of its custom mixes, Greer's efforts to hide its custom mix practices from the FDA, other evidence of Greer's guilty knowledge, and finally, the clarity of the FDA regulations themselves. Let me start with...
on that last point, the clarity of the FDA regulations themselves, it looks like the regulations weren't clear even to the FDA up until 2015 when it provided its guidance.
I think that's not true, Your Honor. This regulation obviously dates back to the 40s, and it's been interpreted consistently the entire way. In fact, the fact that Greer consistently misled the FDA about what it was doing suggests it understood precisely that.
So Greer and everybody else in the industry consistently misled the FDA since the 1940s?
Well, Your Honor, I think the evidence about what other companies in the industry were doing is very conflicting and uncertain. At least Hollister, the largest company in the industry, appears to have only sold custom mixes pursuant to prescriptions, which would be consistent with our understanding of the law. But the FDA said as early as 1997, when it issued its industry guidance prohibiting combination vaccines, that combinations of multiple antigens, biological antigens in a single product required a separate license for the combination product. I don't think there's any indication that the FDA was ever inconsistent in its approach on this score. Indeed, there are references in FDA publications, from FDA panels, Federal Register notices from the 70s and 80s, where the FDA expressed strong concern about the danger of combination products and therefore required separate licenses for them.
And I know there was a warning by the FDA in, I think, 2014 or 2013 to this company. Were there any warnings before that?
There were not, Your Honor.
To this company, to the appellee.
Not that I'm aware of, Your Honor, and I think that's precisely because until 2013, the FDA was unaware of what the company was doing.
Was the FDA inspecting the company before 2013?
They were, Your Honor, and the company was misleading them, and that's let me walk through some of that. Specifically on efforts to mislead, as we note in our brief, in the standard operating procedures that Greer used for creating and revising custom mixes, and this is starting at JA 280 and following, and also JA 2475, Greer required that all custom mixes be identified with the prefix RX. Now, we all know that RX means prescription. Custom mixes were not pursuant to prescription, yet they insisted on including that prefix. They did not include that prefix for their licensed mixes, suggesting an intent to mislead. Similarly, in the 2001, 2005, and 2007 FDA establishment inspection reports, the inspector states that Greer prepares treatment and custom extracts as part of their prescription service. That's at JA 2757, 2799, and 2849. So that's at least 3 separate occasions in the early 2000s where Greer was apparently telling the FDA inspector that their custom mixes were part of their prescription process, not part of their FDA manufacturing process. Similarly, way back in 1994, Greer provided FDA with a list of the 4 different product types, that's a quote, that Greer manufactured in room 145, which is the room where they make custom mixes, and stated that the only applicable one of these categories was individual prescription mixtures of allergenic extracts. No separate mention of custom mixes pursuant to physician's order was made. That's at 2552. And during that same inspection, Greer's chairman told the inspector that in that room, that room was primarily, quote, primarily used to fill individual prescription allergenic extracts. And as far back as 1982, and this is document JA 1510 to 1512, which is a document that Greer only produced on the eve of the summary judgment motion. Greer submitted a sample label for what it called prescription mixtures of allergenic extracts. And their sample label not only had an RX number, it also indicated prescribed by Dr. Baker in the example that we cite in the brief. So for the last at least 40 years, Greer has been consistently telling the FDA that all of these custom mixing practices were occurring.
Mr. Brogard, where do we draw the line between reckless conduct that shows reckless disregard and conduct that shows mere negligence? Where do we draw that line?
Well, Your Honor, I think that line is easy to draw in this case because we have so much evidence of conscious behavior by Greer to hide the fact of what it was doing. I agree there can be difficult cases, but I think it's important to note that as this court held in the Gosselin Worldwide case, that sophisticated businesses operating in a regulatory environment are presumed to have knowledge of the statute that applies to their behavior. Here, if there was any question on Greer's part about what we think is a facially absolutely clear regulation, and 61017 says licensed products may not be combined with other licensed products except as a license is obtained for the combined product. We don't think that's at all ambiguous. But if there was any ambiguity as a sophisticated company in a regulatory environment, we think it is at least reckless or, to use the alternate language, deliberately ignorant of the rules for the company not to seek clarification from the agency. Instead, the company chose to mislead them.
Well, you have a long list of items that you've just gone through that you represent as facts that would be in dispute or facts to which a trier of fact would have to apply a standard. And I understood part of your argument to be that the district court applied an inaccurate scienter standard under the statute. Is that part of your argument?
Your Honor, we have made that argument. I'm not choosing to emphasize it today. There is clearly language in the district court's opinion that we cite in our brief that seems to require fraudulent intent and that seems to require direct evidence of scienter, even though the case law of this court is very clear that fraudulent intent is not required and circumstantial evidence is sufficient to prove scienter. But there's also obviously other language in the opinion that references recklessness and deliberate disregard. So I'm not, we think under the correct standard, there's no question that the district court erred given the information available. As I said, I just mentioned the specific evidence of efforts to hide, to mislead the FDA. There's also evidence of efforts to hide custom mixes from the FDA.
Well, so is the bottom line of your argument not that the district court applied an inappropriate standard, but that there were facts in dispute that barred summary judgment?
Yes, Judge Agee, that is certainly the bottom line of our position. We think the district court's statements regarding the legal standard may give rise to some question whether it was applying the correct standard, but under either standard, we think there is far more than sufficient evidence in the record for this question to go to the jury.
Without commenting on your FCA claim, I noticed you spent about 12 minutes on the FCA claim. Do you really have a retaliation claim here?
Your Honor, we do. I think it is this the subsidiary claim. The district court obviously rejected it, at least in part because it didn't find an FCA violation here in the first place. I think there's so much information I want to get out today on the main FCA claim that I'm keeping my focus there. But I think that Ms. Skibo's own testimony about having told the head of Greer about the problems with custom mixes, coupled with the evidence that from the North Carolina Board of Pharmacy inspection that was triggered by her comments where a Greer employee said, yes, we expected that that employee was going to go complain about custom mixes. So we were sort of expecting this inspection. We think that in and of itself provides a sufficient factual basis to suggest that she had communicated her concerns about potential custom mix fraud to the company and shortly before she was terminated.
Well, your complaint seems to have focused almost exclusively in the retaliation context on something called the slit trial, which doesn't appear to be before us. And with regard to the custom mix, that sort of seemed to be an afterthought, but I wasn't finding in the record evidence with respect to fraud related to that in terms of the retaliation, as opposed to the argument that there was a regulatory violation. And case law seems to say that a complaint about the regulatory violation is not a basis for a False Claims Act retaliation claim.
Your Honor, I think there's some question about the facts there. I think clearly Ms. Skibo's testimony is that she was advising Mr. Roby that they were selling this stuff illegally, that Roby was aware of that fact when he said, we're not going to put ourselves at a competitive disadvantage by not doing this. Obviously, whether that crosses the threshold to suggest fraudulent conduct, given that everyone in the industry understood that they were making products that were being billed to healthcare providers, including Medicare and Medicaid and other government programs, we think is sufficient. But I'd like to keep the focus for the moment back on the evidence of the underlying substantive False Claims Act violation, because there's also additional evidence in the form of the fact that Greer excluded custom mixes from its product list that it sent to the FDA. It excluded custom mixes from the PowerPoint presentation it made in 2011 when the FDA inspector came to inspect the company. It excluded and, in fact, specifically deleted reference to custom mixes from a MedWatch report it knew would be provided to the government. And as we've mentioned in the briefs, it also was not retaining custom retention vials of its custom mixes, which is clear evidence that the company understood that they were not licensed products and were instead trying to pass them off as prescriptions, because as the company told the FDA itself, they tried to justify this practice by citing to the exception in 21 CFR 600.13, demonstrating that that says that allergenic products prepared to a physician's prescription do not require.
Thank you, Mr. Bograd. You've got some time left on rebuttal.
I appreciate that.
Mr. Gass.
Good morning, Your Honors. May it please the court. Again, Mike Gass, representing the defendant appellee, Greer Laboratories. I will, if it pleases the court, I'll be happy to address the categories that Mr. Bograd identified as showing a material issue with respect to whether or not Greer had scienter with respect to the requirement that was never adopted until 2015 that it have a separate license for its custom mixes. Just in context, Your Honor, again, the Judge Bell, after an exhaustive hearing and giving the relators every opportunity to identify any material fact that presented a probative issue, found that they failed to do so under the standard identified by the Supreme Court in Ritchie, in which the court held that they have the burden to show that as the record as a whole supports a finding by a rational trier of fact, and that simply colorable or not significantly probative evidence does not carry that burden. I'm going to start with Mr. Bogard's fourth category because that is the genesis of this entire issue, which is the 1947 regulation, which discussed the fact that you cannot combine separate products without obtaining a separate license. The reason that the entire industry and the FDA for 66 years did not read that as prohibiting custom mixes is because the licensing of the allergenic industry was unique. And that is, there was only one license issued to Greer covering hundreds of its products in 1968. And that continues to be the case. Some things have changed with respect to certain other products that the FDA regulates in terms of the strength, but they all fall under the same license. And so it was the understanding of everybody for 66 years that this was not a requirement of the regulation. And I would like to refer the court to the record where there is very powerful evidence from people in the know regarding that. Specifically, Dr. Robert Esch, who is an industry expert who worked for Greer going back to the 70s, and whose job it was to interact not only with all of the industry participants, but with the FDA, stated that it never was viewed by anybody as being a requirement here. And in fact, the issue never came up. And he says in his affidavit, had the issue come up, yes, Judge Thacker?
Yeah, Mr. Bograd gave as an example Hollister and says that Hollister only sold this pursuant to prescriptions, so that Hollister must have, I think the implication there is that Hollister must have understood what the requirement was. What's your response to that?
The record does not support either the fact or that inference, Your Honor. In fact, the entire industry, once the FDA came out with its guidance, submitted a letter, two letters, saying that the entire industry had been doing this literally since the beginning of time. And the lower court found that that was evidence which strongly supported the fact that this was viewed broadly. It was not just Greer, it was everybody. And significantly, not just the industry, who obviously has a vested interest in here, but the industry representative for the Allergists Society, as well as from an individual doctor who wrote in on behalf of Kaiser Permanente, said the entire industry has been doing this for 100 years. And the reason that the allergists have asked them to do this is because it is safer and more effective to have the manufacturers combine these ingredients, which they require for a whole bunch of their patients, in the manufacturer's clean room, and not send 8 or 10 different vials to the allergists where they have to combine them in their back room. That was the understanding. And what is, I would also point out that our expert, Mr. Cohen, who worked for the FDA for 17 years, saying under this record, it was perfectly reasonable for Greer, along with the rest of the industry, to believe that separate licensure wasn't required. And most significantly, Dr. Schiff, their expert, who they hired to testify that this wasn't okay, ultimately acknowledged that when the issue finally arose in 2013, the FDA was, quote, equivocal, no doubt about it, about whether whether and how this regulation applied to custom mixes. I would also point out that the need to issue guidance by the FDA and the fact that it took them so long to do it was an indication that this was just something that everybody understood was okay until the issue came up in 2013. And as we cited, there's not only regulatory but case law support for the proposition that you don't issue guidance unless there is confusion about what the regulation actually provides. And Judge Bell looked at all those. I just lost the link. Hello?
I think the audio is still on.
You're here.
I've lost my video.
Well, we can see you and hear you. Well, we can't now.
Oh. Can you hear me now as the commercial goes?
Yes, sir. Go right ahead.
Okay, I'll keep talking then. And so when the issue first arose in 2013, the FDA was equivocal, took a long time, and issued guidance, which it's only supposed to issue if there is confusion. So the FDA regulation was not clear. Everybody in the industry understood it to not require separate licensure, including the FDA, and it didn't arise until 66 years later that it was an issue. So I would like to now turn to Mr. Bogrod's other categories where he alleges that that Greer's conduct involved misleading and the FDA and hiding from the FDA the fact that it's that custom mixes were not licensed. Your Honors, with all respect, the record, as Judge Bell found it, could not be clearer. And the evidence was overwhelming that, in fact, Greer, along with everybody else, was open about this, did not try to hide anything. And the starting point for that is it listed custom mixes on its website separate from its prescription services as different ways to get combinations of allergens, allergic compounds. The FDA inspected on site at least 57 times Greer's facilities, and each time it asked for its catalog and its website. The catalog was published on the website, which clearly, as we show in our brief and is in the record, show them as completely different things. One point that I'd like your honors to keep in mind as you're doing this, as you're reviewing the record, the FDA was and is Greer's licensing agency. That is, nobody knows better than anyone what licenses Greer does have and doesn't have. So on the 57 occasions when it was given the catalog, which is openly and publicly shown on its webcast, it was in possession of the knowledge of what was listed and what wasn't. So the notion that we were hiding this from the FDA, again, I respectfully submit, is not supported anywhere in the record. Beyond that, we identify in our briefs 10 different occasions where Greer, in its communications with the FDA, described its custom mixes as being separate from prescriptions. Beyond that, we identify
Mr.
five
Gass,
different letters. Yes.
Mr. Gass, this is Judge Agee. I have a question for you. What's the impact? This comes at a later time. The FDA does issue a form of some type, I forget the number, to Greer, and then they send them a warning letter. What's the impact of those events on the summary judgment standard here?
They don't impact the standard at all. The standard, of course, is whether
well, the standard when you're applying the standard to the evidence that the opposing counsel has set out, what's the impact of those communications from the FDA?
They do not demonstrate scienter on the part of Greer, because the record is uncontradicted that when they first raised the issue, when the FDA first raised the issue, Greer went to them multiple times and said, what do we do? Should we stop making this? And the FDA said, we can't tell you, we haven't decided yet. And the relator's own expert, Dr. Schiff, said that it was reasonable for Greer to keep manufacturing until the FDA came down with a final position, because, as he said, again, quote, they were being equivocal about it, close quote. So by definition, if they were being reasonable, as their own expert concedes, they were not being reckless or deliberately ignorant of the facts. As soon as the FDA came out with its guidance in February of 2015, Greer stopped. I don't have the clock on my screen.
You've got almost 8 minutes.
Oh, okay. So I would like to now address some of the other things that Mr. Bogart raised, which he said suggests that that Greer was misleading or the FDA are hiding the fact. He points to the fact that
I'll let you know when you get to 5 minutes and 2 minutes.
Thank you, Your Honor. I appreciate it. Otherwise, I could get long-winded. He points to the fact that they use the nomenclature RX to designate custom mixes as somehow showing an intent to deceive. First of all, against the backdrop of all the evidence where Greer was open and transparent and communicated directly with the FDA regarding its custom mix practices and put them on its website, that evidence I don't think shows anything. And again, according to the Ritchie case, it has to be the evidence taken as a whole. The nomenclature RX was used internally, and the record is undisputed about this, to designate that this was by a physician order. So a physician could do one of two things to get a mix. It could give a prescription for a specific patient, John Smith, or the allergy clinic of Memphis could say, we've got 40 patients that are all allergic to these 6 different trees. So we would like a tree mix of the allergens relating to those 6 trees, and those would come in and they would get those in a bulk. Both were referred to as RX simply because they were coming from a doctor's order, one for a specific patient, one for the entire practice because they have a whole bunch of patients with the same allergies to multiple allergens. We produced in our brief, and it's in the appendix, the actual labels for custom mixes, which on their face show that they are for a practice, not a patient. We would not be hiding from the we would not be doing a very good job of hiding this from the FDA if who has full access to the labels as well as all of our other internal documentation. If you can see by looking at it that a prescription is for a patient and a custom mix is in a much larger bulk, too much to be used by any patient, and it has on the name of the label itself the name of the practice and not a specific patient. It was not an attempt to hide. It was an internal designation that Greer used that was not intended to fool anybody.
You're at 5 minutes now.
Thank you, Your Honor. In terms of the other references that Mr. Bograd used, I'll take, for example, the 1997 guidance regarding combination vaccines that he talks to, and they relied on this heavily at their motion to on the summary judgment hearing. That guidance does not relate to allergenic extracts. What they have tried to do is because the word antigen appears in that guidance, they try to make the logical connection to say, well, this was obviously about mixing allergies. It was not. In the guidance itself, it defines what it is intended to apply to, which is combination vaccines. And again, that's in the preamble to the guidance. On the website for the FDA, they list the vaccine subsection, which identifies combination vaccines. None of those are allergenic extracts. Allergenic extracts are a completely different subset of what is encompassed under the broader jurisdiction of that section of the FDA. So on the face of it, that guidance itself does not apply to mixtures of allergens. I guess one other document I'd like to call your attention to, and I'm referring in the case law to the Owens case, which this court decided in 2010. The theories in this case have migrated significantly from the beginning. They started off by alleging that everybody in this industry did this, which turned out to be an accurate allegation. And yet, when it became inconvenient to their theory, they tried to argue that, in fact, only Greer did this. An about face which Judge Bell caused to question the candor, their candor with the court. Similarly, as Judge Ajib pointed out, they did not allege at all that the retaliation was based upon custom mixes, but upon some other issues which do not clearly on their face constitute protective activity. This court in Owen stated as follows: the relator's claims have been in a state of metamorphosis. The impression of a suit in search of a wrong is borne out by the failure of the respondent to produce any evidence of deceit. That's exactly what's happening.
2-minute warning.
Okay. After getting more than 28,000 documents from Greer, deposing 19 witnesses, they have come up with not a shred of evidence to suggest deceit or any sort of fraud or recklessness or intentional ignorance, which is what's required under the standard. And having failed to find that, they have tried to to claw in other issues or other pieces of evidence which do not, on their face, show either intent or recklessness or conscious disregard by Greer of these issues. Like the court in Owens, this court should see this for what it is, a litigation in search of a wrong, which after significant discovery they have failed to find, and affirm Judge Bell's holding. Thank you, Your Honors.
All right, thank you, Mr. Gass. Mr. Bograd, you've got some time left in rebuttal.
Thank you, Your Honor. I'll attempt to be brief. I'd first like to respond or follow up on a point that I believe it was Judge Agee made regarding the issue of scienter after the Form 483 was issued in 2013. We think, as I gather Judge Agee does, that at that point it became absolutely clear, if there had been any question previously, that the FDA considered the sale of these custom mixes without license or prescription to be illegal, so that during the period from 2013 forward, there was clear scienter on the part of Greer in continuing to sell these products. The warning letter, the subsequent warning letter itself specifically says, please note that the sale of these custom mixes violates 21 CFR 61017 and should not continue without approval of each custom mixture manufactured under a biologics license. That's at JA 3003. And that continued sales could result in license suspension or revocation. So certainly scienter during that period could be clear cut. I'd also like to respond to the point that Mr. Gass was making about plaintiff's expert, Dr. Schiff. It is true that they got him at one point to use the word equivocal, but I don't think that's a fair characterization of his testimony. When he was asked what he thought the company should have done in this period, he said, what I would recommend is to have their doctors write prescriptions. At the very least, do that. So and that's at JA 2208 to 2209. I think Mr. Gass also mischaracterized the issue of the industry practice letters. At the very end of the joint appendix, I believe this is pages 3661 to 3672, there's a series of email correspondence among the members of the APMA when they were drafting the April 2014 letter to the FDA. Greer wanted the letter to specifically identify custom mixes as mixes that were non-patient prescriptions. Other members of the APMA resisted that characterization precisely because they were not submitting using custom mixes without patient prescriptions. And the ultimate letter that was sent to the FDA ducked that issue and remained extremely vague. Hollister's website specifically refers to custom patient prescriptions. That's at JA 874. And the July APMA letter mentions three separate kinds of custom mixing per patient prescription, custom mixing in the doctor's office, and custom mixing for office use. Only the third one is the one that's at issue in this case and was the only one that plaintiffs contend was contrary to law and Greer's behavior. Mr. Gass would have you believe that Greer was open and notorious about what it was doing with the FDA for decades. If that's the case, it seems surprising that the best evidence they can find is a handful of snippets from letters written in the 80s and 90s in which there are passing references made to custom mixing and prescription mixing without any explanation of the distinction between the two. The fact is that for many, many years, Greer was engaged in this improper practice that was on its face inconsistent with clear FDA rulemaking regulatory requirements. They made considerable efforts to hide it from the FDA, and as soon as the FDA learned about it, it told them to stop immediately. This court said, as I think I quoted this earlier in US ex rel Bunk versus Government Logistics, the issue of fraudulent intention is generally not amenable to resolution on summary judgment. I don't dispute that there are documents that can be read either way, but the fact is that there was considerable evidence of unlawful intent here. The question of scienter properly belongs to the jury, and the district court's grant of summary judgment should be reversed. Thank you.
Thank you, Mr. Bograd. I appreciate, on behalf of the panel, the argument of both counsel, and we're going to take a brief recess before going on to our next case.
Thank you.
This honorable court will take a brief recess. of Appeals for the Fourth Circuit.
Good afternoon. We're ready to hear argument in Peters versus Aetna et al. Mr. Hufford, we'll be glad to hear from you.
Thank you, Your Honor. May it please the court, I am Brian Hufford from Zuckerman Spader on behalf of appellant Sandra Peters. Ms. Peters' husband is an employee of Mars, Inc. As part of the compensation he received as an employee benefit, the right for his family, including Ms. Peters, to be insured under the health insurance plan issued by Mars and governed by ERISA. The health insurance policy is self-insured. As a result, benefits under the health insurance plan are paid out of the assets of Mars. Like many employers in self-insured plans, Mars does not administer its own health ERISA plan. It hired what is known as a third-party administrator. Here, Mars hired appellee Aetna as the claims administrator and paid it a set administrative fee, a set amount per member per month. Aetna was paid as the claims administrator to build a network of healthcare providers who would negotiate discounted rates to provide healthcare services to the plan beneficiaries. And Aetna was also paid through the administrative fee to process the claim for benefits by determining what portion of the medical expenses to be paid by the plans that Aetna administered, including Mars, and what portion would remain the financial responsibility of the beneficiary. This is
Counsel, I think the panel's going to be fairly familiar with the facts, and you can interweave those as you want, but you've got several issues, so you may want to go directly to those.
Okay. Thank you, Your Honor. The key issue here is what happened in the relationship once Aetna was retained as a claims administrator. It subcontracted with Optum Health to basically for Optum to provide claims administrative services with regard to physical therapy and chiropractic services. So in a sense, Aetna was being paid as a claims administrator to process all the claims, to set up a network for all providers, and to process those claims. It then delegated a portion of that responsibility to Optum to do that same thing. And the question is, how is the Optum fee going to be handled? This case is about how Optum and Aetna process the claims. It's about the self-serving way that Aetna interpreted the written terms of the Mars plan, which are found in the summary plan description at JA 3000. The plain meaning of these written terms under ERISA and common sense make clear that the Mars plan is intended to cover only the medical expenses for claims submitted by qualified healthcare professionals. That's the entire purpose of a health insurance plan, to cover medical expenses. Yet Aetna interpreted those written terms to mean that the Mars plan and Ms. Peters had to also pay Optum's administrative fee. In other words, the fee that Aetna agreed Optum should receive for serving as a subcontracting claims administrator. The result is that the plan paid Aetna to set up a network of PT and chiropractic providers and process the claims, and then had to pay Optum again for doing the same thing. The key document in many ways here is the explanation of benefits, which is the form put out by Aetna.
I'm sorry, Mr. Hufford. I need to back up a little bit to standing. What is appellant's stake in the lawsuit here?
Ms. Peters, well, first of all, there's two different ways to look at it. Under the Pender case, Pender versus Bank of America, a beneficiary and a plan can pursue an action for breach of fiduciary duty under ERISA and can seek a disgorgement remedy even in cases where there is a fiduciary profits from that breach, even if the plan and beneficiaries don't have a financial loss. And in this case, we're arguing that Aetna incurred breached its fiduciary duties. And
do you concede that Ms. Peters would not have a financial loss?
No, Your Honor. I was saying even without it, she would have.
Okay.
But moreover, she has a financial loss. Each time Aetna processed the claims, she was assessed her coinsurance based on the increased fee that was intended to apply to Optum, rather than the actual negotiated fee of her treating provider. And that meant she paid too much. In fact, in the brief, we show that she overall was charged more than $300 more than she should have been charged had the plan been properly assessed. Now that's
So what is your basis for Aetna, not Optum, but Aetna's liability here? Do you say they are a named fiduciary or a functional fiduciary or some of both or neither?
The plan formally names Aetna as a claims administrator. And the plan also specifies that as the claims administrator, it gives discretion to Aetna to process the claims, make benefit decisions, and handle the appeals. So it actually is, in effect, a named fiduciary because it's identified in the plan as the claims administrator with that authority. But moreover, in practice, it's the same thing because Aetna makes the claim determination. It processes the claim, it determines how much the benefit is issued, how much should be paid by the plan, and how much should be paid by the beneficiary. And the argument in this case is, in doing that, Aetna acted in effect fraudulently by hiding the fact that it was treating the Optum administrative fee as if it was a medical expense. Now, I think that can be shown best through the EOB itself. And again, the explanation of benefit processes the claim and is issued by Aetna once a claim is submitted. At JA 3146 is an example in the joint appendix of that EOB. Moreover, and I think this highlights how significant this claim is, that EOB is repeated in the American Medical Association's amicus brief at page 7. That EOB starts with listing the provider as being Optum Healthcare. But Optum is not a medical provider. Optum was a claims administrator that had subcontracted with Aetna. And one thing that really shows that is if you look at the plan terms defines Aetna as a claims administrator, and then it defines what Aetna is. And in defining Aetna, the plan says Aetna is Aetna Health Insurance Company and any third-party vendor. The third-party vendor is Optum. Optum, therefore, is under the plan part of Aetna. It's part of the claims administrator services. So it's improper for Aetna to identify Optum as a provider. So then you look at what is processed in the claim in this EOB. It first lists a chiropractic manipulation service with a $40 bill charge with CPT code 98940. That service is what actually was provided by Dr. Schaefer, which is the chiropractor that Ms. Peters actually saw. And that bill, 98940, reflects the one service she actually received, chiropractic services. In fact, in the bill that was submitted by Dr. Schaefer to Optum, which is at JA 5701, that is the only bill that was submitted by that provider. Now, interestingly enough, the EOB
So, counsel, let me make sure that I'm clear on the causes of action that you assert and say survive. If it turns out, for instance, that Ms. Peters, for whatever reason, was found not to have a direct injury, in other words, that her personal monetary losses ended up not being a loss, is it your argument, for instance, that the explanation of benefits is if it's inaccurately or falsely stated, is that a separate ERISA cause of action?
Yes, because it's a deception or in effect a fraud by Aetna because the information it has on here was inappropriate. And that really comes from the second item. But this also shows, I think I can show you there's actual injury here. Because other than the CPT code for the chiropractic service, which again is the only service she received, there's a second CPT code included on this EOB. And a CPT code is a 5-digit number that is used to design each individual healthcare service. The American Medical Association owns and licenses that service, that CPT code. The second CPT code listed on the EOB is an unlisted modality, 97039. Now, that modality, as the AMA reflected in its amicus brief, is designed to reflect an actual modality or a physical treatment for the patient. Ms. Peters did not receive that service, and no provider billed for that service. It was put in there by Aetna to hide the administrative fee for Optum. By using that CPT code, Aetna improperly reflected that as a medical expense. And the American Medical Association in the amicus brief made that eminently clear, stating that was in fact a misleading and fraudulent use of the CPT code. Now here's where this—
So was that, the placement of the CPT code, was that the act of Aetna, the act of Optum, or a joint act?
It actually was a joint act. Aetna was the one that put it in the EOB. It was a joint act in the sense of when Aetna contracted with Optum, Aetna reflected the fact that it did not want to have to pay this out of its own administrative fee. Because remember, it was already paid to provide, to set up a network and to process the claims. It then hired Optum to do that, subcontracted for PT services and for chiropractic services. So it did not want to have to pay that out of its own assets. So it hid that as a medical expense. But it contracted with Optum and required Optum to be paid that way. And in fact, as reflected in our briefs, in many cases, Optum didn't like it. It didn't want to do it, but it was forced to do it by Aetna in order to get the business. Now, what's significant about this, and this goes to the financial injury from his Peters, if you look at the EOB, the amount that's identified as the allowed amount is from this unlisted modality, again, which is improperly characterized as medical. It shows it as being $70.89. Under the plan, Mars is supposed to pay 80% of the negotiated charge, while Ms. Peters is supposed to pay 20%. The actual negotiated charge in this case was $34. That's reflected in a remittance advice that Optum sent to Dr. Schaefer for the service that Ms. Peters actually received at JA 5705. So Dr. Schaefer negotiated to accept $34 for manipulation. Under the plan, the plan was supposed to pay 80% of the $34, or $27.20, while Ms. Peters was supposed to pay 20%, or $6.80. But instead, Aetna applied this to the $70.89. So Ms. Peters was actually overcharged by $7.38 for this one single claim. Instead of having to pay $6.80 of her 20% coinsurance, she had to pay $14.18.
Mr. Hubbard, for purposes of class certification, I understand your common contention, but is there a common injury?
Yes, Your Honor, because this exact process happened over and over again. In our expert report from Dr. Panis, he goes through and analyzes the claims data. What happened here is that Aetna had this exact same process. Every time the claim came in for PT or chiropractic, Aetna would add in an extra charge to reflect an administrative fee by Optum. It had nothing to do with an actual medical expense. And then when it assessed the benefits to be paid by the plan or the coinsurance to be paid by the beneficiary, it would apply that toward the increased administrative fee cost and not to the reduced negotiated charge of the treating provider. So this happened across the board to scores of patients and to scores of plans in exactly the same way. And that's why we believe that it's a very simple class certification issue. Now,
so what's the basis of Optum's liability?
Well, I mean, I'll be upfront here that in reality, Aetna is the only one that really needs to be held liable. Optum is liable because it was part of the plan. We view it as being a fiduciary also, although the district court disagreed with us, because it's processing the claim. It knew what was going on and it contributed to it. And it was in fact a party in interest under ERISA, which meant that it was part of the prohibited transaction of using the plan assets to pay Optum rather than to pay for the beneficiary. But
well, it may have been a party in interest, but what's the basis for holding it to be a fiduciary for ERISA purposes? It seems to be more of a third-party vendor, you know, like somebody you would buy office supplies from in some senses, as opposed to a fiduciary, which doesn't mean the third-party vendor can't enter into an illicit agreement with a fiduciary. But it seems like the basis for holding it liable as a fiduciary is fairly weak.
Well, I guess I would start by saying we don't need Optum to be found liable itself. Aetna is the one who came up with this idea. It's the one that was unjustly enriched. We think Optum can also be held responsible because it did, in fact, was involved in making benefit decisions. It processed the claims, it did the utilization review, and determined what was or was not medically necessary. So for that, it could be brought in as a fiduciary. But again, we don't need that. For the liability here, it really ultimately is Aetna, because Aetna is the one who is unjustly enriched. And again, in looking at what was appropriate remedy under ERISA, the classic type of remedy is disgorgement when a faithless fiduciary ultimately is unjustly enriched because of a fiduciary breach. In this case, Aetna clearly is a fiduciary. It was supposed to process the claims properly. It had already been paid once for its administrative fees. In a sense, Mars had already paid it an administrative fee to set up a network of PT and chiropractic services and to process those claims. So when Aetna subcontracted with Optum and then tried to force Mars as well as the Peters to pay for that, it really was forcing them to pay twice. So Aetna should have been responsible for paying for Optum because it came out of its own administrative. It was therefore unjustly enriched by the amount that the plans and the providers and the insureds, including Ms. Peters, had to pay. And that can easily be calculated.
Mr. Hufford, you've gone over a little bit, but you've got time left on rebuttals. So why don't we hear from Mr. Austin?
Thank you, Your Honor.
Yes, thank you, Your Honor. Earl Austin, I represent Aetna. In our view, this is a fairly simple case. Aetna contracted with Optum for the simple reason that Optum had a network of providers that was superior to Aetna's in the specialties that we're talking about. And Aetna negotiated a flat rate for access to those group of providers. There was no evidence, or even really any allegation, that the flat rate itself was excessive or not consistent with the market. And there was two indicia there. First, it was clear, it was the evidence showed.
Well, the question would seem to be who's supposed to pay that, Aetna or the plan and the plan participant?
Sure. But the choice here, and I did need to make this point, the reason that Aetna did this is because Aetna's rates were already higher. So, for example, just to give one concrete example, in the Carolina region, the rates the average rates under Aetna's network were $109 for a physical therapist. The rate Aetna was able to negotiate with Optum was $88. And their only complaint is that we didn't charge the rate that Optum ultimately paid the downstream provider. But there was no evidence that Aetna could have ever negotiated for that rate. The only evidence was that we negotiated a rate that objectively was 25 to 35% less than Aetna's own network would have provided the same service.
Well, I assume opposing counsel would say that that's what Mars was paying Aetna to do, was to go out into the marketplace and find the lowest price providers and to offer those to the plan, and that's why Mars hired them.
Correct, and in negotiating with Optum, this was completely consistent with that. Aetna, for example, may negotiate with a hospital, and the hospital will have a bunch of downstream rates, and Aetna will negotiate a fixed fee for that. Built into that will be some administrative costs that the hospital would incur. A physician's group will be the same way. In other words, Aetna will often negotiate with collectives of providers. They'll negotiate with a central billing office or administrative office that it will be negotiating for the downstream rates, and it will negotiate a fixed rate for that. This was no different. We simply negotiate a fixed rate for access to contracts that Optum had through its network. And the rate that we negotiated was much less than would have been available under Aetna's. And the record also showed that in 30% of the cases, it was actually less than Optum had paid the downstream provider. And I think if you look at the plan document, which obviously Aetna is given discretion as the claims administrator to interpret the plan documents. In the plan documents, there were two types of providers, two classes, network providers and out-of-network providers. And in every sense, being a network provider was a more favorable posture for patients or for plan participants. If a provider was classified as an out-of-network provider, there were more restrictions on their use and they were much more expensive. For example, had Optum these providers been classified as out-of-network providers, Ms. Peters would have paid, instead of the 20% co-insurance, she would have paid 50% co-insurance. So Aetna interpreted.
Well, as I take opposing counsel's argument, he doesn't dispute the business arrangement that's made, but that using the terms of the plan, that Optum could not be a healthcare provider, and that the charge that the plan set for a plan participant to pay was the negotiated charge with the healthcare provider, which in the example opposing counsel has been using is the fee charged by the chiropractor. So if those are the plan requirements, then wouldn't Aetna have had to separately bargain with Mars for some arrangement in its fee, as opposed to, in effect, back charging the plan or the plan participant to pay a higher rate than the plan appeared to set?
No, I don't believe so, because we were authorized by Mars and we were asked by Mars to create a network. We saw a hole in our network for this particular service. Our network was too expensive. It didn't have enough doctors. So we negotiated with Optum a rate that was 25 to 35% lower than the rate for the Aetna network to provide access to those providers. That was a completely reasonable thing for Aetna to do. And I should point out that the relationship when Aetna was working with Optum on this arrangement, that was not pursuant to any particular specific plan. It was simply putting its network together that would offer then to all of its plans. So it was not acting as a fiduciary, it was a negotiating. And there was no evidence from Mars, there was no complaint ever from Mars that they thought that this was an unreasonable relationship. What's ironic about this case is if we had not negotiated this arrangement and we'd used Aetna's network, everyone would have spent more money, there would have been fewer doctors, but apparently this case would have never been filed. It's only because we negotiated with Optum for a lower rate that this case has been filed. And Aetna's was entitled to discretion under Firestone, and they interpreted this plan to put these Optum providers in the same position as an Aetna network provider so that they would be available at the cheaper rates to plan participants. And the negotiated charge was the charge that Aetna negotiated for access to that network. There was no evidence that there could ever have been any other arrangement. There was no evidence that Aetna could have ever negotiated the agreement that Ms. Peters suggested somehow we should have access at the Optum downstream rates. There was no evidence that that was economically feasible. And to the standing question that was asked at the beginning of the hearing, the injury here has sort of two levels. I think the district judge was very generous with Ms. Peters here because he analyzed the injury looking at her own theory and taking her own theory at face value. He said you don't have an injury, and the only difference that they had with Ms. Peters is that Ms. Peters was wanting to look at just a handful, sort of cherry pick certain transactions and just look at those and pay no attention to the ones where she actually saved money. But the court said, even under your own theory, if you look at the
Mr. Austin, as to Aetna and the specific violation in this case, how is Aetna a fiduciary?
Well, Aetna was not a fiduciary in negotiating with Optum to form this relationship. That was not done with respect to any particular plan. As to administering a particular plan, I would acknowledge that Aetna was a claims administrator and is a fiduciary in administering a plan. But part of the purpose, the central thrust of the claims administrator, is to determine the intent of the plan. And here, Aetna classified these providers as network providers, which made them available at preferential. It gave the patients access to the most number of doctors at rates that were much less than they would have been under Aetna's plan. And that's an entirely reasonable interpretation of this plan under the Firestone standard. And I want to loop back to standing because I think the district court was generous in saying, Ms. Peters, I'll look at it your way. But really, her argument made no economic sense. There was no economic real world scenario where Aetna was going to be able to go to Optum. And keep in mind, Optum's a competitor of Aetna's. There was no way that Aetna was going to be able to go to Optum and negotiate for the same rates that Optum was paying to its downstream providers. There was no evidence that could have ever happened. So the true measure of damages here is if we had not done that, what would the plan and the participants have paid? And everyone agrees it would have been 25 to 35% higher. It would have been the $109 Aetna rate as opposed to the $88 rate that Aetna was able to negotiate. So there's no standing here really by any measure. And it's only because I think the district court said, all right, Ms. Peters, I'll take your theory at face value. Even under your own theory, you don't haven't established damages. And then on the class issues, of course, we would have to go through and look at it and do that same analysis. There are 1,600 plus plans. We'd have to look at the language of every one of those plans. We'd have to go through every participant. When did they meet their deductible? Is it a family plan? If it is, it's a family deductible. When did they seek the service in the year? Was there still a deductible left at that time? If the deductible had been exhausted, then the plan would pay everything. But you'd have to do that over 80,000 times. And I think under this court's precedence, it was not readily identifiable under objective criteria, and the court correctly did not abuse its discretion in denying class certification.
Thank you, Mr. Austin. Mr. Boone.
Thank you, Your Honor. May it please the court, Brian Boone from Austin and Bird for Optum. I apologize for my voice. I've got a cold today, or at least I hope it's a cold. I was pleasantly surprised to hear Mr. Hufford concede that Optum shouldn't be held liable. I just wish he would have admitted that before Optum spent millions of dollars defending a meritless litigation. I won't repeat all that you just heard, but I will note that there's been a lot of talk about Sandra Peters, the terms of her former plan, the Mars plan, the contracts between the Mars plan and Aetna, and Peters's individual benefits claims. You see the same thing in Peters's briefing on appeal. She focused overwhelmingly on her individual claims and plan terms and not on class issues. Excuse me. That, I think, tells you all you need to know about the strength of her class-related arguments. The arguments are half-hearted for a reason. They're meritless. In denying class certification, the district court got it right on the facts and the law and certainly didn't abuse its discretion. The same is true of the court's summary judgment ruling as to Optum. For Optum, the proceedings below played out a little differently. Before the class certification phase, Peters moved to compel discovery under what's known as the fiduciary exception to the attorney-client privilege. She chose to tee up that factual question when she did. The parties submitted briefs and evidence, and the court held a hearing and then issued an opinion. And in that opinion, the court denied Peters's motion and found that Optum served no fiduciary function at all relating to the challenged conduct, which of course is always the question. Peters didn't ask the court to reconsider that ruling and doesn't challenge that ruling on appeal. Instead, in light of that ruling, Peters changed course below. She chose not to seek certification of any fiduciary claim against Optum. In fact, she argued in her class cert briefing that it was undisputed that, quote, Aetna made the challenge benefit determinations and, quote, sent the EOBs related to those claims. That's at JA 5009. You heard the same from Mr. Hufford when he was arguing earlier. So Peters effectively abandoned her fiduciary claims against Optum. Certainly, it seems like on appeal now she's abandoned them altogether. That left only an unpleaded claim for non-fiduciary liability under ERISA Section 50283, but that unpleaded claim ran into all the same problems. To get non-fiduciary monetary relief under Harris Trust, each plan member would have needed to prove several different individualized facts, including that Aetna was performing a fiduciary role when making the challenge benefit determinations, that Aetna breached the fiduciary duty in making those determinations, that Optum knew that Aetna breached the fiduciary duty to the plan in question, that the plan member suffered some concrete injury, that Optum, in fact, made a profit on the member's benefit claims for that particular plan year, that the member could trace some property or profit to Optum, and that it would be inequitable to allow Optum to keep that traceable profit. In other words, that the profit was ill-gotten. All of those questions required individualized answers. They defied common proof. We can take Sandra Peters as an example. Analyzing her non-fiduciary claim against Optum required looking at her individual claims history, the terms of her plan, Aetna's course of dealing and contract with the Mars plan, whether Optum had a relationship with the Mars plan, it didn't, and what Optum knew, if anything, about the Mars plan. In fact, it had never seen the plan. It also required analyzing whether Optum earned any profit on Peters' benefit claims. In Peters' case, Optum made only $22 on the 32 claims for which he sought damages. It made only a total of $1.8 million under the Aetna Optum contracts over the whole span of 5 years. That, by the way, is less than what it spent on this litigation. All of that Peters-specific analysis that I just went through is for just one former plan member from one plan. You'd need to do the same thing for each of the 80,000 plus people in the proposed classes. This wasn't a class action. It was thousands upon thousands of mini trials waiting to happen. There were other problems with the non-fiduciary claim against Optum. Peters couldn't trace any payment to Optum because she never paid Optum. She paid Optum's downstream providers, and the Mars plan didn't pay Optum either. Aetna did. Aetna's payments to Optum weren't specific to any plan or member, but instead went into a general Optum bank account, not exclusive to the Aetna-Optum relationship. You also see in the briefing that Peters cherry-picked a couple of emails from Optum employee David Elton, who expressed some concern, what I would call customer service concern about provider or member confusion. But Dr. Elton wasn't interpreting the Aetna plans. He had never seen the Aetna plans. In fact, no one at Optum ever saw the Aetna plans. No, Dr. Elton was focused on customer service issues. In the same emails, and Mr. Hubbard didn't point this out, Dr. Elton agreed that without the Aetna Optum contracts, Aetna plans and members would be paying more. Optum always believed, correctly, as it turns out, that the contract saved Aetna plans and members money. Optum had no reason to think that Aetna was breaching a fiduciary duty to any plan. Peters also plucked out of the record a few emails offhandedly describing the fee structure as burying Optum's administrative fees in the claims process, but witnesses explained that bury meant only that Aetna required that Optum build its administrative fee into the claims process. Peters ignores all of the evidence, the scores of evidence in the record confirming that everybody involved believed that the Aetna Optum contracts were saving money for Aetna plans and members. No one was trying to cheat anyone out of anything. There's also been a lot of argument today about whether Optum is a healthcare provider. It is, it provides healthcare services, that's what it does. All healthcare services involve administrative costs. Even Peters' proposed expert, Dr. Panis, agreed with that fact. To give one example, no one would argue that a medical group isn't a healthcare provider, even though the group itself, the legal entity, doesn't sit in the exam room with the patient. Peters wants to define healthcare provider to mean only attending physician, but that's an unnatural reading, or an unnatural interpretation of the definition. You see accepted definitions in the record at JA 2860, Mosby's Medical Dictionary, which defines healthcare provider as an individual, institution, or agency that provides healthcare services to healthcare consumers. That covers Optum. The other thing that I'd say, and of course this is Aetna's interpretation of the plan, not Optum's, the AMA can have its definition of provider. Peters can have her definition. Optum could even have its definition. I can have my definition. The court could have its definition. But the Mars plan vested Aetna with discretion to interpret the plan. So the only question is whether Aetna's interpretation was reasonable. And you'd have to go through that same analysis thousands of times to analyze whether Aetna breached the duty to any of the more than 1,600 different plans in the record. And with that, I'll have no further comment. Thank you.
All right. Thank you, Mr. Boone. Mr. Hufford, you've got some time in rebuttal.
Thank you, Your Honor. Both counsel for the defendants continue to stress that there was a good thing for Aetna to have contracted with Optum because Aetna was able to get a reduced price for chiropractic and PC services. And that's fine. We do not challenge that contract. It's not an issue in dispute. We're not saying they did anything wrong. In fact, it's appropriate for Aetna to do that. The question is, who should be paying for that cost? And did Aetna, working with Optum, mislead the plan, deliberately mislead the plan and the beneficiaries in violation of ERISA and the fiduciary duties? There's one document I'd like to highlight in the joint appendix of JA 2692. This is a 2016 memo from an Optum employee when it's describing the process, and it says, quote, one of Aetna's original goals of the service model design with Optum was to bury the administrative fee within the claims process to ensure Aetna did not have to pay a PMPM administrative fee out of their own bank account. Now that really says it all. This is not a question of whether Aetna could go out as part of its claims administrative duties and subcontract something to help save money. and to help find a better network, which it was obligated to do and was being paid to do. The question is whether Aetna can lie about what it's doing, can treat an administrative fee for Optum as if it's a medical expense, can use an actual CPT code falsely to characterize the Optum fee as a medical expense, and then pass that on to the plans and the members. They cannot explain that or justify that, and they didn't even try. Ultimately, this is an ERISA case. It comes down not to some but-for world of what would happen if they hadn't contracted with Optum, which is really a concept sort of out of an antitrust case, but it's an ERISA case. Did they comply with the plan terms? The central basis for the district court's decision here was finding that Optum could properly be deemed to be a network provider, because the plan terms limit benefits to being no more than the negotiated charge of a network provider. The only way Aetna could treat Optum and to treat the Optum fee as a benefit above the negotiated charge of the actual treating provider is if Optum was a network provider. In reaching the decision of the district court, it did not apply the Booth or Helton analysis to see whether Aetna properly evaluated the terms. The court didn't even look at the plan terms. It simply said, well, Optum's a network provider since, quote, it provided the network of therapists to Aetna members. But yet Optum, under that scenario, Aetna's a network provider because under its agreement with the plans, it was providing the network to the plans. And of course, Aetna can't treat its own administrative fee as a medical expense. That's absurd. If in fact, if you actually look at the plan terms, it's eminently clear that network provider is a healthcare provider. Network provider is quoted as is defined as a healthcare provider included in the directory as a network provider. And then throughout the plan, it makes clear, for example, by defining providers as healthcare professionals who are properly licensed or certified to provide medical care. And the plan also says it doesn't cover treatments not prescribed by a physician. That's the only way you get to benefits, is what a professional provider would actually treat. And that could be the treating provider or a facility or the person overseeing that provider. That's not what Optum does. It's not licensed to provide medical care. It doesn't treat the patients. It doesn't provide any care at all. It is a vendor, a third-party vendor. And as I mentioned previously, I think this is really critical. At JA 3063, the Mars plan defines Aetna as Aetna Life Insurance Company, an affiliate, or a third-party vendor under contract with Aetna. So Optum is actually part of Aetna for purposes of the plan. It cannot be treated reasonably as a network provider. Now, I would like to focus one thing on what Optum tried to say in arguing that they're not a fiduciary, et cetera. Our argument is Optum, again, they don't have to be liable to be able to get the remedy of disgorgement from Aetna here. But Optum was a full participant in this whole scheme. It knew what was happening. It knew its administrative fee was being treated as a medical expense. It knew that Aetna was going to use that to pass along the administrative fee. And of course, Optum knew it was being paid by the plans. So it was a full knowledge participant here. But the final point is, I think, on class certification. The defendants try to characterize this as being this complicated issue that you have to look at whether every plan member in the but-for world would have benefited if Aetna had not contracted with Optum. But that's not the question. Every class member here was treated in the exact same way. Aetna took the administrative fee of Optum, mischaracterized it as a medical expense to pass on that cost to the plan and to the beneficiaries, every class member. All of those people can be easily ascertained from Aetna's own information. All of that information can be identified on a class-wide basis to determine how much money Aetna saved by not having to pay out of its own assets for the administrative fee. This is a very simple case, and there's deception here by Aetna and Optum. They lied by mischaracterizing this to the plans. This is not a contractual issue. It's a deception and a breach of duty. And I think the court clearly got it wrong below, both in denying class certification and in granting summary judgment credit. We would ask there be a reversal here.
All right, thank you, Mr. Hufford. On behalf of the panel, I want to thank all counsel for their argument today. I'm going to also thank our courtroom deputy, Emily, and Mike Dean for his technical assistance. And I'll ask the clerk now to adjourn court, and then the judges will reconvene here shortly by video.
Thank you, Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.